As a foreign traveler, having a tour guide at your destination is a big help, especially if you don't know how to speak foreign languages. But the sad reality will wake you up that your compatriots who instead of helping you will betray you in the end. And that's what we'll tackle in this case.
Tomio approached Nagao at coffee shop, invite to join them together with other Japanese. He asked Nagao if he can change Philippine peso. Later on, left Mr. Nagao with Mitamura. After gaining the trust of Mr. Nagao, they ended up at the Leo's restaurant where they had dinner. Nagao's companion placed a pack of cigarettes on his shirt pocket and walked to look for taxi driver. After few minutes, plainclothesman police bodily searched him and found pack of cigarettes contained marijuana. The police brought him to the Southern Police District Station. Accused-appellant Tagahiro Nakajima arrived, followed by Tomio. Both acted as interpreters for Mr. Nagao. One of them informed him that if he is found guilty of possession of marijuana, he can sentence from 6 to 12 years of imprisonment. The two then suggested that Nagao give money to the policeman who, they claimed, demanded $100,000 for his release. Nagao agreed. Tomio and Nakajima informed him that they had advanced the payment of the bribe money to the policeman and agreed to release him. Nagao returned to his hotel escorted by the affiliates. They demanded on him to immediately call his family in Japan. They leashed him and brought Nagao to different hotels from Hotel International to Intercontinental Hotel in Makati. Later, transferred to Philippine Village Hotel and Inbira Condominium in Makati, until his father had already remitted money to the Rizal Commercial and Banking Corporation in Makati.
accused-appellants were guilty as charged because they deprived the offended party, Tatsumi Nagao, of his liberty for the purpose of extorting ransom from him.
Under Article 267 of the Revised Penal Code, as amended by Republic Act No. 1084, the offense is still kidnapping for ransom. Under American rulings, ransom has been held to mean in its ordinary sense as money. Price or the consideration paid or demanded by for redemption of a captured person or persons. A payment that releases from captivity, since the accused in this case demanded and received money as a requisite for releasing Tatsumi Nagao from their hold, whatever other motive may have been involved to do so. The money is still ransom under the law. However, on August 18, 1986, affiliants, through another lawyer, Attorney Dominador R. Santamaria Jr., filed with this court a petition for habeas corpus, which was docketed as GR number 75576. They alleged therein that the decision of the court below in criminal case number 86-45055, subject of GR number 74630, is void and illegal because, among other things, the trial court lacked the jurisdiction over the offense charged as it was committed at the Holiday International Hotel in Rojas Boulevard, Pasay City, not in Manila. Before being investigated, they were tortured, threatened, and deprived of their constitutional rights to due process and equal protection of the laws.
They started hitting my body at the bank while putting handcuffs. They also brought me inside the room where my hand and feet were tied with a rope. They covered my face with a cloth and poured water on my face while police doing interrogation.
They also boxed me. During the investigation, they let me lie down on the table with hands handcuffed, and they also poured water on my face.
Then, on December 4, 1986, the Office of the Solicitor General filed a comment for the respondents in GR number 75578. They cannot avail of the writ of habeas corpus, since the main purpose of the latter is to determine whether or not a petitioner is legally detained. In the resolution of January 29, 1987, we dismissed the petition for habeas corpus on the ground that, for Section 4 of Rule 102 of the Rules of Court, where the commitment is pursuant to a judgment of conviction, the writ of habeas corpus will not lie. On the other hand, April 14, 1987, the Office of the Solicitor General filed a Habeas brief in GR number 74630, wherein reduced the penalty to reclusion perpetua pursuant to the new Constitution of Section 19 of Article 3 of the 1987 Constitution, which abolishes the death penalty and provides that any death penalty already imposed shall be reduced to reclusion perpetua. The assigned errors of both affiliants in GR number 74630 boiled down to the following issues: whether trial court had jurisdiction over the case despite the crime being committed in various places. The court rejected the affiliants' claim of lack of jurisdiction as they voluntarily submitted to the court's jurisdiction and actively participated in the trial. Actively participated in the hearings therein or invoke its jurisdiction may not be heard to question its jurisdiction. Whether the accused affiliants were denied due process in the proceedings. The court found no merit in the claim of denial of due process. as the statements made during custodial interrogation were not used against affiliates and the trial court conducted a fair and impartial trial. Whether the prosecution has proven the elements of the offense charged beyond reasonable doubt. The court found that the evidence for the prosecution has established beyond reasonable doubt that affiliates, together with their co-conspirators, had an elaborate and carefully designed plan to kidnap Mr. Nagao in order to obtain ransom from him. The plan was effectively carried out at lunch on May 2, 1986 at the coffee shop in Holiday International Hotel, when affiliate Tomio Maida, alias Sato Toshio, approached Mr. Nagao. Examination, the plot would be pursued with the assistance of law enforcement authorities. As early as 3 o'clock in the afternoon of that day, Mr. Tomio received a call to inform him that a Japanese was arrested for having marijuana in his possession. It should be stressed that at the time, Mr. Nagao had not yet been arrested by 5 policemen of the Southern Police District for possession of a pack of cigarettes allegedly containing marijuana. He was arrested after 7 o'clock that evening following a dinner at Leo's restaurant.
Wherefore, judgment is already rendered. In GR number 74630, affirming subject to the above provision of Section 19, Article 3 of 1987's Constitution, the decision of the trial court in criminal case number 84-45055. This should not, however, end the story of Mr. Nagao. As adverted to earlier, other parties, namely Mr. Mitamura, a Japanese national, and 5 policemen from Southern Police District, could be deeply involved in this conspiracy to kidnap him for ransom. Our examinations of the records fails to show that Mr. Mitamura and policemen were investigated or prosecuted in connection with this case. This court would be remiss in its duty if it were to close its eyes on this matter, more specifically on the alleged involvement of the policemen.